military justice and the law presented to you by Bulani Tseu. In this episode, I'll be discussing the Directorate of Military Judges, especially with regards to the manner in which soldiers who serve as military judges are assigned, and that will be compared with how civilian judicial officers are appointed. The Military Discipline Supplementary Measures Act 16 of 1999, the MDSMA, provides that the Minister of Defense and Military Veterans may assign soldiers to serve as ordinary military judges, senior military judges, as well as a director of military judges, based on the advice given by the Adjutant General. Unlike before 1999, when soldiers without legal qualification could preside in the courts martial, the MDSMA stipulates that a legal qualification is a requirement for any military judge. Accordingly, a soldier assigned as an ordinary military judge must be an officer with a rank of major or lieutenant colonel, and that person must have been involved in the administration of criminal justice or military justice for a period not less than 3 years. Senior military judges must be officers with a rank not lower than that of colonel, and that person must have practiced military justice or criminal justice for a period not less than 5 years. Ordinary military judges, as well as senior military judges, are located in the Directorate of Military Judges, and that directorate is headed by an officer known as the Director of Military Judges. The requirements for a person to be assigned as a Director of Military Judges is the same as those that are required for senior military judges. In other words, such a person must hold a rank not lower than that of colonel and must have been involved in the administration of criminal justice or military justice for a period not less than 5 years. This is therefore the reason why the Director of Military Judges is deemed to be a senior military judge. The primary function of the Director of Military Judges is to issue policy directives to other military judges. But the Director of Military Judges must not influence or interfere with the judicial business of other military judges. An assignment as a military judge is triggered by a vacancy in the Directorate of Military Judges. Accordingly, once there is that vacancy, the Adjutant General must conduct a due and diligent inquiry to ensure that a person who is fit and proper is assigned to serve as a military judge. The MDSMA, however, is silent on the scope that the Adjutant General must cover in that inquiry. Anecdotal evidence reveals that the Adjutant General recommends for assignment judges or aspirant military judges without having conducted interviews with such persons. This, for me, is problematic because it makes it clear that the entire process is veiled in secrecy, as it is not subject or subjected to public scrutiny. This position must be compared with how civilian judicial officers are basically appointed. Judges of the High Court, Supreme Court of Appeal, and the Constitutional Court are appointed pursuant a stringent or rigorous process conducted by the Judicial Services Commission, the JSC. The JSC is established in terms of Section 178 of the Constitution and is an independent entity. In other words, it does not form part of the executive arm of the state. The JSC is composed of members of the judiciary. Chief Justice in particular forms part of that. Law teachers from local universities, as well as politicians form part of that. Once there is a vacancy for a judge, that particular post is advertised, and persons can nominate others whom they believe that they fit the profile of a judge. And that other person must basically confirm his or her willingness to basically function as a judge. So once that is done, a subcommittee of the JSC, known as a screening committee, will then go through the nominations in order to arrive at shortlisting candidates. The shortlisted candidates will then be interviewed by the JSC. The media is allowed to be present during that process, and the media may report on the particular process. In other words, the public generally is kept abreast with regards to what may have transpired during this appointment process. The JSA will then deliberate as to who amongst the candidates are best suitable, and will then make a recommendation to the President of the Republic of South Africa in that connection. The President will then appoint a judge based on such recommendations. The magistrates, on the other hand, are appointed in a different fashion, in the sense that an entity responsible for the appointment process of magistrates is known as the Magistrates Commission. Once there is a vacancy in the magistracy, an interested person or an aspirant magistrate would apply using the prescribed manner, where he or she will have to submit education qualification, among other things. The Magistrates Commission will then interview aspirant magistrates and make a recommendation to the Minister of Justice and Constitutional Development regarding suitable candidates. The Minister of Justice and Constitutional Development will then appoint a magistrate based on such recommendations, or after consulting with the Magistrates Commission. In an attempt of comparing apples with apples, pears with pears, I have looked at certain foreign jurisdictions regarding the manner in which they appoint their military judges. In this regard, Canada is a chosen jurisdiction because of the fact that its laws, they resemble our local laws. There is a military judges selection committee in Canada that is composed of members of the civilian bar as well as members of the military community, among others. And this committee is basically responsible for the appointment process of military judges. Soldiers who believe that they fit the profile, or rather they meet the prescribed requirements, will then apply. Then the military judges selection committee will, subsequent to that, conduct interviews regarding who is best placed to fill that vacancy, or the vacancy that may have been in existence at the time. So once that is done, this committee will make a recommendation to the Minister of Defense. If the Minister of Defense is satisfied that the entire process was done correctly, he or she will then endorse a particular aspirant military judge and submit his or her recommendations to the Governing Council, in other words, to the Governor General, when he's acting together with the Prime Minister and Cabinet Ministers. The governor in council will then appoint a military judge based on those recommendations. Essentially, the manner in which our civil and judicial officers are appointed, as well as the military judges in Canada are appointed, is transparent, and that must be contrasted with how our military judges are appointed, or rather are assigned, because they're not appointed, are assigned. So it will be best, in my view, for South Africa to ensure that there is an independent committee to perform the role that is performed by the JSC or the Magistrates Commission or that of a Military Judge Selection Committee, in order to subject aspirant military judges to a stringent selection process that will ensure that persons with proper legal acumen are assigned to serve as judges, military judges for that matter. So in this episode, basically I wanted to show that the manner in which our military judges are assigned is not transparent, and in my view it is wrong. It will be wrong to leave the assignment of military judges to one person, the Adjutant General. If the committee can exist, that independent committee can exist, it will ensure that there is meritocracy in the assignment process, which is a circumstance that, in my view, leaves the current approach, with much to be desired. So I trust that you enjoyed this episode. In the next episode, I'll be discussing the security of tenure of military judges with regards to whether their assignments place them in a position of being able to discharge their duties, their judicial business, without fear, favor, or prejudice, and whether the periods of those assignments is sufficient enough to ensure that our military judges act with the necessary independence. Whoever has not subscribed, please subscribe.